Good afternoon and welcome to our lecture series at SepaRope, Separation of Powers for 21st Century Europe, which is a cooperation between the University of Amsterdam, the Amsterdam Center for European Law and Governance, the University of Gothenburg and the University of Helsinki. And today, my name is Christina Eckes. Today it is my pleasure to welcome Joana Mendes from the University of Luxembourg. She's Professor of Comparative Administrative Law there. And it's my particular pleasure to welcome her back because before she joined the University of Luxembourg, she was with us at the Amsterdam Center for European Law and Governance. And we will be speaking about discretion and EU agencies' constitutive powers. And this is, of course, something that keeps us very busy within SepaRope. So without much further ado, Joana, the Zoom screen is yours.
Not the floor anymore, exactly. Thank you very much. Thank you very much for the introduction and thank you for all of you attending. It's a pleasure to see many of you again. So I'll be talking about discretion and the powers of agencies. And when one thinks of discretion and powers of agencies, what immediately comes to mind is Meroni and short selling. I will not go back into that, into discussions that have been had many times before. In particular, to those of you who are familiar with the discussion, there would be very, very little new that I could add in that respect. So don't worry, I will not give you a lecture on Meroni and short selling. But I will take Meroni and short selling, in particular, the limits of the powers to the EU agencies that have been set by the court. I will take it as a starting point. A starting point for the discussion on conceptual issues of discretion on the one hand, under the current constitutional strictures that remain, and those are that discretionary powers of agencies need to be subject to judicial review and must be sufficiently, for that purpose, need to be sufficiently delimited legally. And also a discussion on the assumptions that we have regarding the role of legal norms and the role of judicial review in constituting and constraining administrative discretion. So this is going to be my focus. And I'm going to be referring to, I will give you the examples from the Single Resolution Board. And although I'm referring to constitutive powers of agencies, I do not have in mind agencies in general. What I have in mind are specific powers of agencies that are attributed in particular to EU financial agencies and to the Single Resolution Board, and powers that have a series of cumulative characteristics. Their mandates are delimited by open textured norms. That is a first condition. Those norms resort to evaluative and goal-oriented terms that delimit the factual predicate of the norm, the if part of the norm. The agencies need to conduct prognostic assessments in conditions of uncertainty, and those prognostic assessments, which are the reason why the agencies have been created in many of these instances, are essential to determining the meaning of the norms. And in acting in conditions of uncertainty and in defining future-oriented action, the agencies need to arbitrate between conflicting public and private interests. So this is the scope of what I'm referring to. And my argument is twofold. First, the binary scheme that we often adopt to characterize the powers of the agencies based on Meroni, the quasi-mechanical implementation on the one hand, and the policy-making powers on the other hand, that binary scheme overlooks the constitutive powers of agencies. It overlooks that the law's capacity to constrain those powers may be relatively weak, even where discretion is framed by predefined legal criteria and is clearly within the reach of judicial review. And my second point is that the persistent application of the Meroni strictures and subjection of the powers of the agencies to judicial review that conditions the scope of discretionary powers that they may have does not avoid the attribution of constitutive powers to agencies. What it does is it distributes these powers throughout different executive bodies. And I'm going to argue that the powers of the Single Resolution Board illustrate that, which is slightly counterintuitive because the whole allocation of resolution powers to the Single Resolution Board has been premised on the possibility to distinguish discretionary from non-discretionary decisions, and I will get to that in a bit. I will proceed in essentially three main parts. So I will explain what I mean by constitutive powers to begin with. I will then discuss conceptual issues regarding discretion that I think are important to understand the scope of the powers of the agencies. Here in this part, I'm going to rely extensively on the work that I've done previously on discretion that some of you know. And finally, I will argue that the legal regime of the SRB, as I was saying before, the legal regime of the SRB's powers of resolution confirm my position. So what do I mean by constitutive powers? Here I will start with two examples taken both from the single resolution mechanism. The first example is the Single Resolution Board may exercise directly powers of national competent authorities over private entities when it considers that two conditions are fulfilled. One, those authorities have not properly addressed warnings on non-compliance with the SRM regulation that have been addressed by the agency. And they do not properly address, they imperil the consistent application of the resolution standards. So this is one example taken from the SRM regulation. The second, and more importantly, perhaps, or more crucial to the whole legal regime, is that the Single Resolution Board may resolve a financial institution if three conditions are fulfilled: when the financial institution is failing or is likely to fail, when there is no reasonable prospect that private sector measures may prevent the failure in a timely way, and third, when resolution is necessary, and these are the legal conditions that I'm outlining here, when resolution is necessary in the public interest in the terms that are specified in the regulation. And those terms are when resolution is necessary and proportionate to, among others, avoiding significant adverse effects on financial stability and to protecting public funds. So these are the two examples. And these powers may be analyzed from very different angles, but what I wish to highlight here is their scope and nature. They are not discretionary powers in the sense of Meroni. They are not wide powers that allow, wide discretionary powers that allow the making of economic policy. They are, if we follow this binary distinction, they are clearly defined executive powers. But these clearly defined executive powers can hardly mean in this case the management or administration powers or powers of practical execution, which is the association that one tends to have when talking about clearly delimited executive powers. This binary distinction that I've been talking about, many acknowledge that it is imperfect, and it is by now widely accepted that it does not prevent agencies from having some degree of discretion. But what I'm arguing is that it is of little use to grasp the scope of the powers that the agencies have. The decision-making powers of the agencies in the examples that I gave are clearly legally circumscribed, there's no doubt about that. But the very determination of whether the SRB can act or not is a decision of the SRB itself that largely evades legal circumscription. What do I mean by this? Whether the resolution of the bank can avoid significant adverse effects on financial stability and protect public funds. This is a decision of an executive body that implies necessarily attributing meaning to what is an adverse effect to financial stability, which implies making sensitive policy choices that balance the competing interests that are at stake. In the case of banking resolution, the protection of public funds, the protection of investors, of depositors, of client funds, and of assets. So the fact that, and my claim is that the fact that the SRB can determine the conditions under which it will act, means that it may acquire constitutive powers. It stipulates, or the SRB in conjunction with other executive bodies, they stipulate the normative understandings that define the meaning of core aspects of the legal regime that they need to apply, and define the public interests that they have been entrusted with pursuing. So it is executive bodies that are defining via their own practices and the understandings that they develop through their own practices, what is financial stability, what are adverse effects or significant adverse effects, and what other undetermined legal concepts may mean in the specific circumstances in which they need to act. So in carrying out these powers, the SRB both conditions in varying degrees the powers of national administrations. In the example that I gave, it can replace the decisions of national administrations in certain circumstances. But it is also determining, in another example, in the other example, it's also determining the rights and obligations of private parties, because it is at the core of a series of decisions of executive bodies that define whether the bank is going to live or whether the bank is going to be resolved. For those of you that are familiar with the intricacies of the banking resolution, I would like to note that the SRB does not take this decision alone. That's why I've been referring to executive bodies. I will get to that in a bit later on. But for now, I would like to stay more at the conceptual level. So in exercising discretion, or better, in exercising these constitutive powers, the SRB is exercising discretion as well. It is determining, under conditions of uncertainty, it is determining the course of action that it considers to be more appropriate in view of the public policy objectives that it needs to protect and that it needs to pursue. That means that it's making choices, it's making value choices that are concretizing the normative programs that have been converted into legal norms and that have been defined in political processes and that have been converted into legal norms. All this space of decision-making, this space of discretion is happening within the limits of a legally constrained environment. But these quite detailed legal mandates do not prevent it from making normative choices, do not on how it's going to pursue these different public interests, do not prevent it from defining how these public interests are going to be protected in our societies and giving meaning to the public interests that in a sense are both the purpose of their action and the basis of their action. So let's go back to discretion, and this is the second part of my presentation, the part relying on the work that I have done on discretion. So when the SRB acts, or generally when EU agencies that have structurally similar powers to the ones that I've mentioned, when they act, they have discretion not in choosing the course of action that they're going to take, but they have discretion their discretion begins at the very definition of whether the legal conditions to act are fulfilled or not. This is usually termed jurisdictional discretion. And this is a term that is used in particular by Paul Craig. In the case of banking resolution, the discretion of the SRB, so the ability to make choices on how to concretize these normative programs that are enshrined in legal norms, begins and ends when it is determining the legal conditions of action. So it does so naturally via complex technical assessments, which are the very raison d'etre of the existence of the Single Resolution Board. Its discretion begins and ends when it determines, together with other bodies, that there is no reasonable prospect, and I'm quoting, that private sector measures may prevent the bank's failure in a timely way, that the resolution is necessary and proportionate to avoiding significant adverse effects to financial stability, to protecting public funds. So at this point, the objections, or you may be thinking of two things, or either of two things or both, that determining the meaning of these undetermined legal concepts as much as they entail complex technical assessments, is not a discretionary choice, does not constitute discretion. So this is one possible objection to what I'm saying. And the second is that even if it is, even if we consider this to be discretion, it is subject to judicial review. So I will focus mainly on the first point, on what is and what is not discretion. But in doing so, I'm also addressing the second, on the scope of judicial review of the court. The two are intimately connected. So the objection that this is not discretion, the reasons for this position are very well established in what I may call a conventional understanding of discretion, of administrative discretion. And these are mainly two reasons. This is not discretion because these are undetermined legal concepts. They are a matter of law, and hence they are subject to, they are a competence of the court. Second, the definition of the meaning of these concepts requires complex technical assessments, which, yes, may give a certain margin of discretion to the agency, but does not enable the agency to make, or does not enable it primarily to make value judgments, balance public interests, determine how one public interest should prevail over the other. It does not enable them to make policy choices, and if it enables them to make policy choices, it enables to do so in very restricted terms. So in the example of the single resolution board, the meaning of significant adverse effects on financial stability, the example that I've been giving, obviously requires the resort to specialized knowledge that is verifiable, even if it might be the object of different expert assessments. The function of this and the function of this concept is to delimit the conditions under which the SRB can act. So it's defining the lawful conditions of executive action, and as such, it cannot attribute discretion. This would be the prevailing view, because it is a matter of law. It is a matter of interpretation. It is a matter in which the court has the last word. What I argue against this position is that it is not possible or desirable to make to segment these different aspects of discretion. What is it interpretation as a matter of law? What are technical assessments, and what is discretion? And this is an argument, as you know, or some of you know, that I've made in my previous work, and in a position that I will briefly explain, making three main points. First, there are plenty of gray areas between what is considered a technically complex assessment, what may involve a policy choice, and those gray areas make this distinction, diminish the analytical value of this distinction. So the interpretation of an undetermined legal concept obviously depends on expertise, an undetermined legal concept of the type that I've been talking about. It is also influenced by policy considerations. It is also influenced by the perceptions that administrative decision makers have at each point in time of how they should act in a given political and economic context. So it's not only a matter of legal interpretation. To distinguish these different elements, so to unravel the different types of choices that are involved in making this type of interpretation, may be only at the end a formal exercise of conceptual rigor, which may be important. I do not dispute that. But the verification of whether there are significant adverse effects on financial stability is in itself a politically loaded assessment, in itself an assessment that the very verification of which can cause political consequences. So the two, I think that it's very difficult to detach this aspect also from the context of interpretation. So it is possible to distinguish these different types of choices, but they interact to such an extent that in practice, it makes it artificial to give them even a legal treatment. My second point is that I'm pointing to a certain formalism that is inherent in making these distinctions. And this formalism engenders in a sense, distort our views of what the powers, on the nature and scope of powers of the agencies, and also on the possibilities of controlling them judicially. They convey a formal view on the authority that the agencies have, that do not reflect the constitutive nature of their powers. They may presume the possibility of judicial review because, after all, these are matters of law, and matters of law that are subject in principle to full judicial review. So they clearly presume the possibility of judicial review, but in instances where judicial review may need to be limited because intense judicial review may be precluded due to the technical complexity of the matters at stake, but in particular because of the political sensitivity of the underlying assessment. So my third and last point is that these distinctions can become normatively problematic. These distinctions between undetermined legal concepts, technical discretion, and discretion proper, what they do is that they dissect the different types of choices in administrative decision-making to identify those that should stay within the responsibility of the administration and those that that should be subject to full or limited judicial review. So far, so good. But in doing so, they're also separating law from discretion. They're also conveying the idea that discretion is a type of choice where courts in principle do not enter. So it is, they do not interfere, or insofar as they do interfere in that space of decision-making, they do that only to verify whether the technical assessments that underlie the decision have been technically correct. So it conveys an idea of discretion as a space that is free from legal normative considerations. So these distinctions, what I claim is that they have arisen from a judicial paradigm of discretion. So they have been advanced and used with the rationale of ensuring, prevailing rationale of ensuring judicial scrutiny of discretion, but they hardly account for the reality of discretion and in which these different types of assessments are then deeply intertwined. So my third and last point today, going back to the legal regime of the single resolution mechanism and to the powers, specifically to the powers of resolution of the single resolution board. The single resolution board was adopted, the single resolution mechanism, the regulation was adopted just after the short selling judgment came out, a few months after. And it reflects very clearly the division, the Meroni binary distinction between wide discretionary powers and clearly delimited executive powers. There are many aspects of the regulation, in particular, the legal regime of banking resolution, which is the core to the regime of resolution, that clearly make evident that the legislature was intent on clearly delimiting the scope of discretion that the SRB has. This explains a very, very intricate procedure of resolution for the determination of resolution, in which, as I was saying before, early on, the single resolution board cannot act alone. It cannot determine alone whether resolution is in the public interest or not. So I will spare you all the details. It's a procedure that goes over 2.5 pages, I think. But what is relevant here is to say that this procedure presupposes the distinction, the possibility to distinguish what are the discretionary aspects of the decision and what are the non-discretionary aspects of the decision. Why? Because the SRB, in combination with other actors, in particular the ECB, determines the conditions that need to be fulfilled for there to be a decision, a positive decision of resolution. But it needs to send its assessment to the Commission, and the Commission can object to the resolution decision with regard to the discretionary aspects of the decision. And the Council can oppose the SRB's finding of public interest. And it does so because the Council wanted to be able to block the undesirable political consequences of resolving a bank at EU level, which has obviously an impact on financial stability, and it also has an impact on the fiscal sovereignty of the states, so of the member states. So the Council, it is clear, the regulation says that the Commission can object on matters that are discretionary matters, and specifically the Council can object to public interest assessments. So this clearly limits the scope of powers of the SRB. It does, but it does, my argument is it does not prevent the SRB from having the constitutive powers of the type that I was talking about in the beginning. Why? Because the complexity of the procedure is such, the time frames in which all this happens, all needs to happen, the objection, all needs to happen within 24 hours. And the stakes for financial stability are such that this basically means that any decision of resolution needs to be ready even before the procedure is started. So that obviously means that the SRB needs to be involved, and the other institutions as well need to be involved at every step of the way, or at the crucial steps. And it means that the SRB is very likely deeply engaged in the legal, economic, and political aspects of a resolution decision. So what I argue is that instead of limiting the powers of the SRB, which it does formally, what this highly complex procedure does is that it distributes constitutive powers throughout a tightly knit chain of administrative collaboration whereby no executive actor can act without the other. But this also blurs significantly the possibility to identify who is doing what, who is deciding what along the procedure. And this again goes back to my point of it being difficult in practice to segment the different aspects of the decision. And the fact that it's then difficult in a procedure that is premised on the distinction between discretionary aspects of the decision and non-discretionary aspects of the decision, that is premised on the intervention of different institutions based on this distinction, but that at the same time blurs significantly who is doing what because of the administrative collaboration that needs to intercede and the involvement of the different institutions. This exemplifies, in my view, how normatively problematic it can be to build a core aspect of a legal regime anchored on a distinction that I argue does not hold in practice. And this is what I had to tell you today. So I look forward to all the remarks and questions that you may have.